We are now live. Welcome to the second meeting of the Civil Law Subcommittee. And we're going to be discussing three bills. We're going to start off with House Bill 428. And we have the Chief Justice here to help us with it. Chief Judge, Judge Fader, do you want to, so the bill allows for a former judge who previously won an election to judicial office to be recalled for temporary assignment, even if the judge's most recent service as a judge was terminated by losing an election. Can you just tell the subcommittee why it's necessary?
Sure. The reason why we've requested this is because there have been several judges in the past few election cycles who have declined to run for re-election, at least in part, because they didn't want to lose the ability to continue to sit in senior service were they to lose that second election, which second election for a circuit court judge comes at least 16 years after having started service as a judge. And to remove that disincentive to continue active service is the purpose behind this amendment. Mm-hmm. And as I mentioned when I introduced this with respect to the full committee, it's at least my understanding, having watched those elections, that in elections in which a judge has lost in a contested election, the issue has not been their competence or temperament or anything to do with their fitness for continued service that has been at play in those. Those, of course, have been election losses when the judge has been newly appointed. There hasn't been an election loss for a judge who's been running for re-election, but I think that in part might be because the draconian consequence of not being able to ever serve as a senior judge has caused some of these judges, at least in part, to decline to run again. So it's really to remove that disincentive to run again and continue in active service that is behind the motivation behind this bill.
I have one more question, which is, if at this point, with the law is written right now, if you are not reelected, you cannot serve, there's no way to serve as a senior judge. Is that correct?
That is my reading of the law, yes.
Okay. So, okay.
If you're not reelected, meaning if you run for reelection and lose, there's no way to continue to serve.
Right.
If you just step back and don't run for reelection, then you can serve as a senior judge for as long as the court certifies you. Because that answers a question that Delegate Moon and I were having earlier. This isn't about you having a temporary assignment for like an asbestos matter, and there's one judge who really is an expert in this, and therefore you need to make sure that that's the judge that's appointed to this. That's not what this is about. This is about being able to be a senior judge. Correct.
Okay, fair enough. Any other questions? All right, I am going to I'm going to call 1, 2, 3, 4, 5, 6. I've got enough. I'm going to call this one for a vote. Is there any other more discussion before we call the vote? All right, I tend to do it this way, so I'm going to do it the way that I've always done it. Everybody in favor of this legislation, please either raise your hand or say aye if you're off camera. Okay, is there anybody opposed? Okay, perfect. That was unanimous with the people that were on screen. Terrific. Thank you very much, Your Honor. And I know you're going to testify over in the Senate, so we treat you much nicer. Just remember that.
Thank you very much. I appreciate the consideration, and have a great rest of your day. Thanks very much.
Thank you. All right. We are going to hold on. Okay. Delegate Foley says she doesn't have the right link. I sent her the link. Let me just resend it to her real quick. I'm going to start. Why don't we just start the discussion on? Let me do this real quick. Holy. Okay.
Subcommittee Chair Cardin, I will say Delegate Foley, and I believe one of her staff is in fact in the waiting room. I can go
Okay.
ahead and let them in now.
Perfect.
I'm
Yeah,
sorry,
let's do the House Bill 10 now.
Okay.
Charlotte, you can let Rebecca in now too.
Put Rebecca in if Lorenzo Bellamy is in the waiting room, if Brad Rifkin's in the waiting room, and Delegate Foley.
Excellent. I've let all of them in. Sorry, Holly. I was having a little bit of trouble for some reason. I don't think I copied your number down
That's
correctly.
okay.
But we've
You're
got
doing
everybody.
great, Charlotte. Thank you. Thank you.
But we've got everybody coming on in.
All right. Delegate Foley, we've been dealing with this bill now for this is House Bill 10. We've been dealing with this bill for a couple weeks now. It's my understanding that you have offered an amendment to your bill. So why don't we take up that amendment first?
Okay.
See where we are with that amendment as it's your bill, and then we'll take up. I think that that Delegate Erican has an amendment as well. So why don't we start off with you?
Okay.
Remind very quickly in like 30 seconds, remind us what the bill does and what your amendment does, or if Brad is more appropriate to offer the amendment or explain the amendment, that's fine too.
No, I think I can do it, Delegate. And thank you, Mr. Chair. Let me just say that we inadvertently sent you an amendment that we did not want added to the bill. So the amendment we're talking about, no, we said two. So the amendment we're talking about.
But otherwise, we should just proceed.
Right, somebody is not on mute.
Okay, so the amendment we're talking about is the amendment that was from 220, the reprint is 2/23/26.
Okay.
There was an earlier one from January that is moot, okay, that we don't want. Does that make sense? So there's one amendment. And it is, Brad, do you, maybe Brad knows the number of the amendment. I don't have the number.
I
the
have
num-
the Delegate Foley. It's
go ahead.
Okay.
the one you're talking about is House Bill 10, so it's going to be 983423/1.
Thank you.
You're welcome.
Okay, so briefly, Mr. Chair, what this bill does is it allows for these legal notices and legal advertisements that are required for counties and municipalities, governments basically, to put in media. It allows these to be placed not just in print media, which is what the law says now, but you could also have the option of putting it in a digital media. If the digital media and the print media meet certain criteria that are specified in the bill. Is that enough a description for it, or do you want more?
I think that can be good for us to start.
Okay.
So let me now, okay. First, any questions from any of the members of the committee on the amendment? So I'm going to ask a question. I just want to, for clarification. Okay, so this is only for legal notices. Is that correct?
Yes. I say that hesitantly. I think it describes in here what kind of notices, and I think it is legal, what we would say in the parlance, legal notices. So it's only governments, right? It's
Only
not
right,
yeah.
only government notices. So
Right.
Real estate, if a realtor was required to put some notice in about eviction or something to that effect, this wouldn't be included in this. Is that my understanding?
I don't believe so. I may have to refer to Brad, who's the lawyer on this, to tell me, but I think that's right. Is that correct, Brad?
The intent is for it to just be the legal notices.
Okay,
Right.
that's what okay. And
But if it needs clarification, I see Rebecca raising her hand.
okay, well, we're going to get to that. I just want to let me ask one more question, then Rebecca, don't
Sure.
worry, we'll make sure we get all the questions answered. Okay, so the other question is, this was a discussion from last year and this year. It says and not or in the bill, and that's the way that was at least something that was done that is making sure that you're not prohibiting or encouraging people to stay away from print. Is that fair to say? I just want to make sure.
Yes, I think that's fair to say. I would, Mr. Chair, if I could point out, though, that the amendment we submitted changes that slightly. It
Okay.
does say print and digital publication, but then it adds a sentence that says, or a digital only publication that covers local news or information in more than 3 counties in the state. So it does say print and digital, and that is aimed at print because they all have a digital component, right? But this also adds or a digital only publication that covers local news or information in more than 3 counties in the state. That's that is the amendment, part of the amendment that we submitted.
All right. Very good. Okay. That was Delegate McComas, by the way, saying she's sorry she's not listening to your to your bill.
Okay. I'm sorry she is too.
All right.
Okay.
Are there any other questions or thoughts based on that information? Okay. I know that Rebecca is chomping at the bit, so why don't we let her ask? Is there a question about this amendment?
No, it's a clarification, like legal
Okay.
notice. I just want to make sure everybody knows. I think, and I haven't seen Delegate Foley's amendments, but if it is only government notice, that's not legal notice, that's government notice. You have notices that come out of, as Delegate Embry knows, the Register of Wills. You have notices that come from foreclosures. You have notices that come from private individuals. Those are all called legal notices. So I just want to make sure that you all know the terminology so that you can make the decision that's right for you.
Right. So, and the intent, Brad, is to have this be government notices?
The will of the committee is fine with us. I think we want the option, as you know, representing the banner, to be a part of this industry in regarding publication. So the way we drafted that particular amendment was certainly an attempt to at least constrict to an extent the digital only. I'd heard on prior subcommittees or the prior subcommittee sort of, this is a banner only amendment. Well, if you want to take it to digital only in all, in one county, that's fine. But I didn't think that the Press Association would want that. So that's
Right.
why we drafted this amendment that way.
And let me just add that this is the language that was already, already, I think, in the
Existing
law.
statute.
Yeah,
It
the
is.
existing
Yep.
statute as the definition of this.
Mm-hmm. Okay.
And it does say certain advertisements, this is a description, certain advertisements in counties and municipalities in the state requiring certain digital publications before publishing certain legal advertisements or legal notice, and generally relating to the publication of legal advertisements and legal notices in counties and municipalities in the state.
Right. So legal is what your intent was, not government. Just making sure that
No, I
that
think
was the-
it's pretty, I think it's pretty,
right. But given
Yeah.
that the definition of legal is more than government,
right,
it's a broader population, right?
right. I mean,
I
that
think we're
part
trying
we-
to trying to expand it across the board, quite
Yeah.
frankly. The way it's currently referenced is the intent.
Yeah, we didn't pay attention to that part, truthfully.
Okay.
What we did was we just added an additional platform. That's what we wanted to do.
Right. Is this, and then I'll hold off. Delegate Erickson.
Thank you. So I just want to make sure I'm understanding. Originally, it was supposed to be just legal notices, but now that we understand that the definition is broader, the intent has shifted to all of those things, or? And what are they? I understand government notices and legal notices, but could we just get maybe Holly knows, like a list of what all this entails? and
Yeah, and
includes?
I'll just refer everyone to the fiscal note, but also just to clarify, legal advertisements and legal notices include, and this is not an exhaustive list, but the appointment and election of government officials, specify judicial activity and judgments, business entity and real property actions, meetings and decisions of government bodies, or other specified occurrences and events as required under law.
So it sounds to me like the intent, the intent of Delegate Foley's amendment is for it to be legal notices, not to be government notices. That was the intent, and that's what the amendment does. Right. I'm just want to, okay. Delegate Embry.
I think you made the point. I just wanted to add that as a matter of fairness, I agree with Ms. Snyder's what she said. I think it does apply, and I think that's become clear to all legal notices, regardless of whether it's government or a private citizen. I just want to, obviously, based on my experience with my bill in past years, I would just think it would be unfair not, because this will save money and
Yep.
create more options, and I just think it would be unfair to limit it only to governments. So, thank you.
So just to be clear, you believe that it should be legal notices. That's the appropriate term.
In my view, yes, I support the bill
Okay,
as drafted
enough.
with the amendment.
All
Yep.
right. I'm gonna call a vote on this amendment. Is there anybody who has any comments before we take a motion on the amendment? All right. Is there a motion on the amendment? Delegate Embry, it sounds like you're the one who's most engaged on this.
I enthusiastically move the amendment.
All right. So can I get a second?
Second.
Okay. All those in favor of the amendment, raise your hand. Okay. And I'm assuming that we have a few opposed. Delegate Eric Hand's opposed. Very good. Okay. All right, the amendment passes. Now, I know that we have another amendment. I think that, do you, Delegate Eric Hand, do you want to describe the amendment and make sure that they're not mutually exclusive, the two amendments? So that's why I want to make sure, but let's
I don't think they are, but Holly can tell us because
Okay.
she has a copy. But
Perfect.
essentially, this would be triggered if there is no print available. Essentially, if we're going to distill it, that's basically what the amendment does. It also talks about the timing of the when the first notice is run, and I can let Rebecca talk a little bit more about the details about that. But that's the substance of it, is that this would sort of go into effect when there was no print available.
Okay. Rebecca, do you want to describe it any different, any more? And go ahead.
I think that's essentially what the amendment does, that it prioritizes the print publication because it has the verifiable audience. You know where things are going. It has accessibility, archivability in a way that digital does not. It's not a mature enough market to have that. And it also creates a pathway when there is no print publication. If there is no print publication in a jurisdiction, then it could go to a digital-only publication with the requirements that Delegate Foley has stipulated. It also limits the bill to be just government notice. This conforms more readily to what's in statute in the Dorchester bill that passed, I guess, 2 years ago. And it solves the problem that local government was having, which was timing of their very small print publications. It also does not give a sweetheart deal to one publication. It preserves the ecosystem of news. And I'm sure Brad has things to say about that. But that's what the bill does.
Right, I understand. No, I think it's, and I appreciate that you think that this is a redheaded Eskimo, or the amendment makes it a redheaded Eskimo, which is the term that I learned back in 2003. So, yes, Brad, go for it.
So I guess it feels like it kind of undercuts the intent of the amendment we just included, right? So we made digital only an option alongside of print and digital. So an amendment that effectively says that digital is only available in jurisdictions that don't already have print and digital, I'm not sure how that jives. Additionally, and maybe Rebecca can enlighten me, I don't know what jurisdictions in Maryland don't have print and digital today. So it sounds to me like this is just effectively rendering, the digital only option obsolete. And the intent of the bill is certainly to make digital only an option for government and other legal notices. So that's my pushback. I'm not sure on the timing piece and the other part of the amendment, which seems less problematic, but certainly concerned about this particular part of the amendment, which to me just undercuts the purpose.
Mhm.
There are no jurisdictions in which there is not a print publication, and print and digital are very different. We've talked a lot about the verifiability of audience. Notice needs to hit the people in a very defined way. And there is not a neutral body in existence that says, this is the way we verify audience for digital publications in the same way that you have it for print. And that is a simple fact. And what the amendment that Delegate Foley is offering and the bill that you're contemplating says that within just a couple months, you're going to upend an entire ecosystem to benefit a unicorn organization that is a fabulous news gathering organization. And I just do not feel like that is good public policy. You do not want to upend. You will kill the Afro. You will kill small local publications because the banner has the benefit of scale, lots of dollars behind it, and they're already saying, oh, we'll run to the bottom of the market. And so if you want to have diversity in your news media, this is a piece of it. And I just, obviously I think it's a bad idea. We support Delegate Erican's amendments because we feel like that creates a pathway for change, but doesn't rush it and doesn't turn everything on its head in a moment.
It's only a pathway for change in response if there is no jurisdiction if there is a jurisdiction that no longer has print and digital, which you just said every jurisdiction does. So I think it's, we're just talking about diversifying options and lowering the cost to taxpayers. Mako and others, I believe, are encouraging the committee to do that. So.
Right, Delegate Foley.
Thank you, Mr. Chair. I just for your information, Virginia already offers this kind of option. It's a little bit different scheme because there was that I don't understand because there was some court decisions involved there, but they already have this type of option available. And I do think that, I considered the amendment that Delegate Erican is offering to this committee, and as the sponsor of the bill, of course, it's up to the committee whether you accept any amendments. I'm not saying that, but as the sponsor of the bill, I rejected that because I think it does completely undercut what this bill is trying to do. I certainly appreciate that there are a lot of stresses on local media. I don't see, and I spent a lot of my career working to promote local media. I don't think that that this is the end of local media or print media. I think what's going to happen is print media is migrating to digital only media. That actually is happening in a lot of jurisdictions. And in terms of being a large publication with a lot of resources, the Washington Post is a large publication with a lot of resources. So I don't know that really should be, it's not a factor for me anyway in weighing this. So thank you for letting me speak.
Yeah, Delegate Erican, last bite at or not maybe last bite, but you get to have at least the final word on your amendment. Go ahead.
That is so kind of you, Mr. Chair. Thank you. I've had a bit of a a transfer. I mean, I know last year I was a supporter of Delegate Embry's bill, I believe. Because I do want to see costs go down, but also since then I've learned a little bit more about specifically the Afro and talked to some older folks who I think are just not quite as savvy online. And I do have a worry that some of the older folks who would really care about some of these issues will be negatively impacted if they lose access to, I mean, look, if it just immediately shifts over to, folks only putting it online, I'm glad it saves them money, but some people that actually needed to get access to this information may not anticipate the shift is happening and may not understand that they're just not going to have access to it the way they were before. And now they need to go online to see it. I mean, I still help, my parents sometimes using websites and they're young. So anyways, so my feelings on it have shifted a little bit since last session, because I want to make sure we're not ostracizing a group of people that would actually really deeply care about the stuff that's being posted and may have a harder time getting access to it.
Great. Okay. Any other thoughts or comments? Let me just see. 1, 2, 3, 4, 5. And just make sure we still have a quorum. Okay. Let's vote on. So, Holly, let me just ask you: Is there a mutual exclusivity issue with these two, or could we pass both amendments without worrying that they cancel each other out, so to speak?
Well, they don't touch on each other in terms of the way they're drafted, but I do think per the discussion that they are counter to each other, if that makes sense. So no, they don't touch on each other, as I could put them together into one, but
Right.
yeah,
Okay.
I think you understand. They
Yep.
One is undercutting the other one.
Okay, very good. Thank you. Okay, let's call the vote. Let's on Delegate Arakan's amendment. All those in
Mr.
yes,
Chair, there's been
yes.
no motion, just to.
Oh,
So
apologize.
move favorable.
Okay, and is there going to be is there a second on the amendment? I don't see David or Frank, but I am listening for them to see if they're going to second the amendment. Second the motion, excuse me.
Well, I mean, I'm almost inclined to second it if she wants the vote, but if we don't have a second, it also tells me how the vote's going to go. What's your poison?
I'm always a fan of holding the vote, as you well know. I roll vote everything.
I was thinking the same thing as you, Delegate Moon.
Okay.
Yeah.
All those in favor of the Arakan amendment, raise your hands. We have 1, 2. I know that, and Delegate Bellamy is also voting in favor. All those opposed to the amendment, 1, 2, and David is you're okay. Very good. The amendment fails, unfortunately, by 1 vote. Very close. Okay. Thank you all very much. Let's take the bill as amended.
I move
Is there a
favorable.
motion? And is there a second?
Second.
Okay. All those in
Question?
favor of the bill as amended, raise your hand or put your little hand up, Delegate Conaway. Okay, very good. And anybody opposed is Delegate Arakan is opposed. Wonderful. Thank you. And Delegate Conaway is opposed. Okay.
No,
Very-
no.
You're in
no,
favor
no.
of the bill. You're in favor of the bill. Okay. I just want to make sure.
Yes.
Okay. Thank you all very much. And thank you, Lorenzo. Thank you, Rebecca. Thank you, Brad, for being here. I appreciate it.
Mr. Chair.
Thank you, Mr. Chair.
Yes. Okay, let's move on to House Bill 466, which is our final bill. We brought this up. This is an Embry bill that we're bringing up for discussion purposes. Delegate Embry, do you want to discuss quickly what the bill does? 1, 2, 3, 4. We still have 5. Good.
Thank you so much
6, actually.
for bringing it in for discussion. So this is a bill Maryland's one of the last holdouts, holding on to contributory negligence, which I think everyone here has heard a lot about and knows. So I won't talk about that. And so this is an attempt just focused on vulnerable road users, because there's a real mismatch in power between someone driving a car with the insurance company and their lawyers behind them, and a person who's hit on a walking, most commonly walking, but on a bike or on a horse or anything that's not a car. Vulnerable road users was defined in a bill that Delegate Dana Stein brought previously. So we're building on that. Again, it's almost identical, not quite as one of the witnesses explained.
I hate to interrupt you, Delegate
Oh,
Embry.
no.
Did you
Please do.
invite some folks? Do you want us to
I
make sure?
did. Are they there? I did.
Charlotte, is there anybody in
I
the
was,
waiting room?
yeah, I was just typing in the chat,
Right.
did not want to interrupt, but we have, Jed Weeks in the waiting room at the moment who I can go ahead and let in.
Thank you.
Do you want him to? Yeah.
Yes, please. Yes.
Yep.
So it is slightly different from the DC bill in that it's a little harder in Maryland to move forward, because we require that the person who suffered the injury first has to show that they were responsible for less than 50%. So we actually have a slightly tougher standard for plaintiffs in the bill we proposed than DC. But anyway, it would allow when a car hits a vulnerable road user, that the person has access to comparative negligence if they can show that they were responsible for less than half of the damage. So you heard from all the people and why they oppose it. But I really think this is just a matter of fairness, and the arguments about insurance, really, it's hard to make them when this is the case in all the states that have the cheapest insurance in the country. So with that, I will stop talking. Thank you for bringing this to the subcommittee.
All right. Is there anybody who has any questions about this? No. Okay. Mr. Weeks, do you have anything you want to add to what Delegate Embry spoke about?
Thank you for having me. I don't have a ton to add. I would just say that I think one of the key pieces of opposition we heard was the potential for it to increase insurance rates, and the opposition referred to Delaware recently changing to comparative negligence. I just wanted to point out that study was actually in 1984, because they passed that transition 42 years ago. In Washington, D.C., when this similar carve-out was initially created in 2016 and expanded in 2021, we've seen no evidence of disparate insurance rate increases. And so we've just been focusing on that much more relevant piece of information. Thank you.
Okay, great. I have a question for you, Delegate Embry. Do you see this as the pathway to us moving towards comparative negligence generally, or should we be taking up the entire issue right now versus this small sliver?
It's a really good question, a fair one. I since law school, have struggled with why we have contributory negligence. It doesn't make sense to me conceptually, but I will say that from my perspective, what motivated me to bring this bill is because of this mismatch that you have, again, lawyers and insurance companies on one side and nobody on the other. And I think that and also we don't have great data to show you, but a lot of anecdotal evidence that insurance companies deny right out of the gate. They just say contrib, deny, 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 deny. And so I think it is affecting insurance behavior. I wish I had a study to show you, but that's certainly the experience of many individuals, including those who testified. So that's the reason I'm bringing this. I have no personal intention to bring any other bills. Not that matters, because someone else may, but from my perspective, this is distinguishable from the issue at large. But if someone else brought a bill to eliminate contributory negligence, I would probably support it.
That doesn't surprise me, I can tell you that. Can I ask you then philosophically one more question, because we're getting close to the end here.
Yeah.
But let's just say, for the sake of argument, that we had a way of grading liability, and we found that one person was 55% and the other person was 45%. It's a car accident, and both cars got into some pretty bad damage. Forget about personal injury or a medical injury. I'm just talking about property damage. The one who was found to be 55% liable would have to pay basically 45% of the damages, even though their car may have been more damaged than the 45% one, right? Or
You're
cost more.
assuming, so the cars hit a vulnerable road user.
No, I'm just talking, I'm right now I'm looking at, I was just talking about two different cars, but let's take it the other way. Let's say, okay, let's say that you have a vulnerable pedestrian crossing the crosswalk, and the guy slams on his brakes, and they were not in the crosswalk, so they're contributory negligent. Okay, they're not in the crosswalk, they're dressed in black. Slams on his brakes and cracks an axle because he stops so quickly. And they are contributorily negligent because they were not in. And they're determined to be, he's determined to be 55%, but the damages to the individual were minor. The damages to his car were much more serious.
Well, the driver can countersue if there's a legitimate theory of, that is possible. I mean, hypotheticals make me a little nervous, but.
Right, but if he wouldn't it be, in theory, wouldn't they find the same liability
right,
percentages?
So under this bill, unlike DC, the vulnerable road user is only entitled to the proportion of damage that they are not responsible for, if that makes sense. And if that's not clear, I'm happy to amend.
So we have $20,000 worth of damage to the car, medicals of $2,000 to the individual, and the individual gets 45% because they're determined to be 45%. They're considered to be 45% at fault. The other guy's considered to be 55%, so they get 55%. Right?
I think that's how that would work out in your hypothetical, which to me, I mean,
does that
sounds fair to me? To me, it's fair that you would want to apportion the damages based on liability, not
would
totally
you add all?
one.
Do you add all the damages together, or is it just the damages for the individual and then?
You would, I mean, assuming it was correctly pled and litigated, you would add them together.
Oh, so it would be the 20,000 plus the 2,000, 22,000, and then they would proportion it out accordingly?
I mean, if you had a theory that the pedestrian, right, and that was alleged.
So the pedestrian would actually wind up paying, they wouldn't be able to recover, but they would wind up paying close to half of the damages if most of the damages were sustained by the vehicle.
Yeah, I mean, I just don't see that. Yes, so we want to give the courts the ability to fashion results based on the actual culpability or actual negligence or whatever the actions of the two parties. I don't know that I have a perfect answer for your hypothetical because there's a lot of
I just always wondered
but it is trying to get at that. Right, that's the problem with contributory negligence. There's no ability to.
Deliarchy, and I apologize. I was going off on a hypothetical.
That's okay. We are so used to it after spending 8 years together on the subcommittee. That's either you or me. So here's my hypothetical. I'm imagining like what the chair had said a minute ago about sort of expanding it. I know you had said since law school you've been uncomfortable with contributory samesies, and I didn't even go to law school. So I'm imagining in my head, and you guys with the legal minds can tell me if this could ever present a problem in court. Are we creating sort of like unequal paths here? So the same vehicle could hit, for example, a car and, injure somebody and also hit a bike in another lane at the same time. There's a remedy for the person on the bicycle. There's no real remedy for the person in the car, despite, both having catastrophic outcomes. Is there any potential legal hangups when we go to court if we end up going to court over this
Well,
somebody
that's a fair
smart.
point. That is true. This would be limited to the only people who could benefit would be the person not in the car. It's legally, I mean, it's not unconstitutional or precluded, but yes, I mean, you raise a fair point about treating how we assess
Right.
the relative
Yeah.
importance
Yeah.
of those.
We're making kind of a value judgment on
And then-
whose potentially identical injuries are worthy of compensation, whose aren't. I don't know.
But yes, I mean, I take your point. But of course we know that if you're in a car and you hit a person not in a car, the likelihood of bodily injury is, dramatically more than if you're in a car with
Yeah.
airbags and all the, I mean, cars have been designed for
As
many
somebody who's
years to
been
be
hit,
safer.
as somebody who's been hit by a car on my bike numerous times, by the way, I
It's
know.
more
And
vulnerable.
here you are. You're still kicking it. You shouldn't tell people.
Well,
We're not going to be able to pass this
luckily
bill if you
it
tell that
wasn't at
story.
high speed. Luckily it wasn't at high speed. Thank
Oy
God.
vey. All right, that's just so it won't have a constitutional issue. So that's all I was really wondering. So
No,
okay,
but it's a
thank
fair
Delegate
point
McComas.
about policy, fair policy point. Thank you.
Thank you for joining us, Delegate McComas.
Thank you for allowing me to. No, I thought I could eat lunch and be at the Calvert House at the same time and take care of business. It wouldn't work. Quick question. This is a procedural question. I was going to vote for Delegate Arakan's amendment, and obviously I missed it because
Right.
I was waving my hand, and in other words, I
I
wasn't
will-
plugged in.
Well,
So,
yeah, it was 4-2, and
okay,
it will be 4-3. That's perfectly
right.
fine. That's fine.
so it wouldn't matter. Okay.
No,
All
but
right.
I will make sure that you're in the vote.
Okay, thank you. I appreciate it. Sorry about that. I digress.
Okay. All right. So is there any, so we're not gonna vote, but I do appreciate this. I want everybody to think about this and think about the policy implications. It's as a person who handles some personal injury matters, it is very interesting to think about how this opens up the ability for victims to really be able to get something in a narrow way that makes sense. So, but at the same time, there are some policy implications and there are some inconsistencies, as Delegate Arakan mentioned. One more thought. So if we brought up Delegate Arakan's question in my hypothetical, so if we determine that the total damages to the pedestrian was $2,000, to the automobile that hit him was $20,000, it's $22,000. The pedestrian is determined to be 30% at fault. So they would get 70%, right?
Well, the pedestrian has to show that they're less than 50%. I'm sorry.
Right.
So they'd be entitled to their share.
So the 70%, they would be entitled to 70%.
I think if I'm following your hypothetical, I believe that's correct.
So, but wouldn't the other car be entitled to 30% but for the fact that the car is not a vulnerable pedestrian, a vulnerable individual. So therefore, they're banned from any recovery. So if the pedestrian is determined to be 90, actually, I guess it wouldn't work because the pedestrian has to be 49% or less responsible.
I think Delegate Arakan's point is really that if two cars hit each other, contributory applies. If a car hits a person, then this bill would kick in, and that is treating the two people hit. One's in a car and one's not. It is treating them differently. That is true.
Yeah. If a car hits another car and that second car hits a pedestrian who was contrib, then the pedestrian could in fact recover, but the first car that's hit could not. That's basically what Arakan's saying. Right. Yes, Mr. Weeks, and then we're gonna go. We gotta let people have some lunch.
I have an anecdote here that's relevant, but in the interest of time, I don't need to share it.
I'm sorry. Go ahead.
I was going to say, but the car that got hit would still have a cause of action potentially if they were not contributorily negligent.
If they were not. Right. If they were, assuming that everybody's contrib, like that's to be the assumption in the hypothetical.
Right.
Yes, Mr. Weeks, quickly, go
Yeah,
for it.
I'll just put it in an email. It's just an anecdote about how it is working now, but I want you guys to get your lunch. So
All good. Thank you so much. Thank you all very much for joining, and thanks for the votes earlier, and we will see you all in committee.